Okay, let's unpack this. Imagine a really high-stakes legal battle where the power of the presidency itself and its influence over global trade, maybe even your everyday purchases, hung in the balance.
Yeah, that's pretty much the scene.
That's the story we're unraveling today. We're exploring a truly significant court decision just landed from the United States Court of Appeals for the Federal Circuit concerning presidential tariffs.
And this isn't just, dry legal jargon. Our aim today is really to shed light on these fundamental questions of executive power, emergency declarations, and frankly, how trade policy gets made, or sometimes unmade.
Right.
By the end of this, you'll have hopefully a clear understanding of what happened, why it's such a big deal, and what it could mean for international commerce, maybe even the goods you rely on.
We're looking at quite a stack of sources today. We've got the court's majority opinion, some really powerful concurring and dissenting views, too,
Hmm.
and even a peek into how this is being chewed over online. Our mission, really, is to pull out the most important nuggets of knowledge from this complex legal landscape, give you a shortcut to being genuinely well-informed about presidential power, tariffs, and, well, what happens when the courts step in.
Let's do it.
So let's start with the tariffs themselves, the actual subject of this whole legal showdown. This court case, it revolved around two distinct types of tariffs the president imposed, both declared under a law called the International Emergency Economic Powers Act, or IEPA.
Right, IEPA. And that act is usually reserved for, well, actual international economic emergencies.
Exactly.
What's truly fascinating here, I think, is the sheer scale and scope of these actions.
Yeah.
The first set, let's call them the trafficking tariffs, they landed on February 1st, 2025.
Okay.
And these were pretty broad, slapping 25% duties on essentially all articles coming from Canada and Mexico.
Wow, 25%.
Yeah. And products from China, they initially faced a 10% duty, which then got hiked up to 20%.
And the justification.
The White House justified these by declaring a national emergency, linking them to opioid trafficking and what they saw as the failure of these countries to adequately address the threat. It wasn't entirely simple, though. There were some initial tweaks, like duty-free treatment for Canada and Mexico on, small value shipments, de minimis stuff.
Uh-huh.
But that was later rescinded for China. So a bit of back and forth.
Okay, so that's one set. And just when we thought that was a lot, on April 2nd, 2025, another wave hit, the reciprocal tariffs.
Ah, yes, the reciprocal.
And these were, well, incredibly broad. They started with a baseline 10% duty on imports from nearly every country with a significant trade relationship with the U.S.
Nearly every country.
Yeah, but it didn't stop there. On top of that baseline, additional duties ranged from 11% up to a staggering 50% on a per-country basis. What was the president's rationale this time?
Well, the president again cited an unusual and extraordinary threat, but this time it was framed primarily around a lack of reciprocity in trade, disparate tariff rates, and other economic policies they felt were contributing to large U.S. goods trade deficits.
So, perceived unfairness in trade levels.
Basically, yeah.
Yeah.
It was a clear signal about an imbalance the administration perceived. We even saw China's specific rate under this go on a real roller coaster,
Oh, yeah.
jumping from 34% up to 84%, then 125%, before actually briefly being lowered back to 10% for a period.
Wow. I can only imagine the headaches for businesses trying to plan their imports.
Exactly, almost like playing tariff roulette with their supply chains.
It sounds like a massive, complex, and constantly shifting economic landscape. But okay, at its core, these two sets of tariffs, the trafficking and the reciprocal ones, they were both framed as responses to national emergencies under IOPA.
Correct.
So what was the fundamental legal question the courts had to grapple with here? Did IEPA's power to regulate importation actually give the president that much authority?
Exactly. That was the absolute crux of it. The central question was whether this broad authority under IEPA really extended to imposing such incredibly wide-ranging tariffs.
Okay, so the initial ruling came from the Court of International Trade, and they sided with the plaintiffs. That was a group of private businesses in several U.S. states.
Right.
They basically said these tariffs went beyond the president's IEPA authority and permanently stopped them, enjoined them. The government then appealed, and that's where the Federal Circuit Court comes in, hearing the case en banc.
Which means all judges on that appeals court reviewed it together, not just a smaller panel of 3. It signals the importance of the case.
Right. Big deal.
But before diving into their decision on the tariffs themselves, the Federal Circuit first had to establish that it even had the right to hear the case. Jurisdiction.
Always the first step. So how did they determine jurisdiction?
Well, the court confirmed it had jurisdiction, basically, because the executive orders imposing these tariffs claimed to modify the Harmonized Tariff Schedule of the United States, the HTSUS.
Okay, the HTSUS. Remind us what that is and why modifying it is so key for jurisdiction.
Sure. The HTSUS is essentially the official U.S. government list of every single imported product, along with its specific tariff rate. And crucially, it's considered statutory law.
Meaning part of the law passed by Congress.
Exactly. And that's the key. Because any challenge to a modification of this statutory list of tariffs, it immediately triggers the special jurisdiction of the Court of International Trade.
Ah, okay.
And then the Federal Circuit gets the appeal. This whole structure ensures that all these tariff disputes are heard by courts with specific expertise in trade law.
Makes sense. Keeps things consistent rather than having different courts maybe issuing conflicting rulings.
Precisely. Uniformity is the goal.
So with the court's jurisdiction confirmed, the critical question remained, did IEPA actually give the president this tariff-imposing power?
And the Federal Circuit delivered a pretty resounding answer. They affirmed the lower court's decision.
Meaning?
The tariffs were not authorized by IEPA. Full stop.
Oh. Wow. That's a massive decision, especially for businesses caught in the middle. What were the key reasons the majority opinion gave for this?
The majority opinion really hinged on several crucial legal principles. First, and maybe most fundamentally, was their textual analysis of IEPA itself.
Looking at the words of the law.
Exactly. The Act lists various presidential powers: investigate, block, regulate, direct, and compel, nullify, void, prevent, or prohibit. All quite strong verbs. But here's the key insight the court focused on. It notably does not explicitly mention tariffs, duties, customs, or taxes.
Those specific words are missing.
Correct. And the court highlighted that when Congress intends to delegate the power to impose tariffs, it usually does so with crystal clear language, often with specific limitations built in. They pointed to other trade statutes, like the Trade Act of 1974, where those terms are used directly.
Okay.
Plus, they noted the Constitution itself draws a clear line, separating the power to regulate commerce from the power to lay and collect taxes.
So two distinct powers.
The court essentially said, look, if Congress wants the president to be able to tax imports via tariffs using this emergency law, it needs to say so, plainly and clearly. You can't just infer it from regulate.
That distinction seems incredibly important. What was the next major principle they invoked?
This brings us to something really critical, the major questions doctrine.
Okay, what's that about?
This isn't just legal jargon. It's effectively a powerful judicial brake pedal. The court basically said, look, if the president is going to make an economic policy change of this magnitude, one that's, in their words, unheralded and transformative, affecting trillions of dollars in almost every country, Congress needs to give explicit, crystal clear permission.
Not just rely on broad emergency powers.
Exactly. Think of it like this.
Right.
If you hire a plumber to fix a leaky faucet, right? You wouldn't expect them to suddenly start remodeling your entire kitchen without a new explicit agreement.
Good analogy.
The court's saying the president can't use IETA to fix a leak and end up remodeling the entire trade economy without Congress specifically authorizing that massive scope of work. And the scale was massive. The government itself estimated the economic impact of these tariffs at between $2.3 trillion and $3.3 trillion.
Trillion with a T.
Yeah, a truly vast undertaking, and one that departs significantly from how IEPA has historically been used, usually for freezing assets or targeted sanctions, not economy-wide tariffs.
That really puts the scale into perspective. Okay, textual analysis, major questions doctrine. What about past cases? Did precedent play a role?
Absolutely. The court looked closely at prior case law, specifically a precedent known as Yoshida II.
Yoshida II.
This case, which actually came up under IEPA's predecessor law, had indeed recognized the president's authority to impose some tariffs, like President Nixon's temporary 10% surcharge back in 1971.
Okay, so there was some precedent.
There was, but the key here is that Yoshida II emphasized strict limitations on the scope, amount, and duration of those tariffs. It was very narrow. The Federal Circuit found that the current trafficking and reciprocal tariffs were, in their words, unbounded. They far exceeded the narrow confines of what Yoshida II permitted. So it's not that tariffs were never allowed under emergency powers according to precedent, but Yoshida II drew a very tight box around it.
And these new tariffs just blew that box wide open.
That's essentially the court's reasoning. Applying broadly, indefinitely. It was just too far beyond the Yoshida II limits.
Okay, so the majority opinion delivered a clear ruling. But it's rarely unanimous in these complex cases, right? We also saw some judges, in a concurring opinion, argue for an even stricter interpretation.
That's right. There was a powerful concurring opinion that actually went even further than the majority.
How so?
This view, led by Circuit Judge Cunningham, asserted that IEPA grants no authority whatsoever for the president to impose tariffs. Period.
None at all.
None. This opinion argued that the term regulate simply does not inherently mean tax. And if regulate were interpreted that broadly, it would actually make other explicit powers in IEPA, like the power to prevent or prohibit imports, entirely seem kind of redundant. Why list those if regulate covered everything?
Interesting point.
And this concurring opinion really powerfully underscored the constitutional principle that the power to tax, the power of the purse, rests exclusively with Congress.
The fundamental separation of powers.
Exactly. It's a core tenet. Congress holds the strings of the national wallet. The executive can't just decide to levy taxes on its own, even in an emergency, unless Congress explicitly says so.
Okay, so we have the majority saying these specific tariffs weren't authorized, and a concurring opinion saying no tariffs are authorized under IEPA. But then on the other side, there was a strong dissenting opinion arguing the tariffs were authorized. How did they justify that view?
Well, the dissent maintained that the term regulate importation in IEPA is actually broad enough to include tariffs.
So the opposite interpretation of regulate.
Pretty much. Their reasoning was, look, since IEPA also grants the president the power to literally prohibit or prevent imports entirely, shut down trade completely, then imposing a tariff, which is arguably a less extreme regulatory tool, should certainly be included within that power.
A sort of lesser included power argument.
You can put it that way. They also pointed to the history of emergency laws, which often do confer broader authorities than non-emergency statutes might.
And what about the concern, the major questions doctrine concern, about delegating too much power to the president without clear instructions? How did the dissent address that?
They argued that IEP's existing standards requiring an unusual and extraordinary threat to national security, foreign policy, or the economy, linked to a foreign source, under a declared emergency provide sufficient intelligible principles.
Intelligible principles,
Yeah.
that's the key phrase for the non-delegation doctrine.
Correct. That doctrine essentially asks, how much power can Congress give away? It says Congress must set clear instructions, these intelligible principles, so the executive branch isn't just making up the law as it goes. The dissent believed IEPA had those necessary guardrails.
Okay.
Particularly, they argued, in the realm of foreign affairs, where courts traditionally grant the president more leeway, more deference.
And did they address the specific tariffs differently?
What did? On the trafficking tariffs, the dissent disagreed with the majority's idea that a really direct link was required between the tariffs and the opioid threat. They argued that using tariffs as leverage to try and change foreign government behavior, much like in the historic Dames and Moore case involving Iranian assets back in the day, is a permissible use of IEPA authority.
Using economic pressure for foreign policy goals.
Essentially, yes. For the reciprocal tariffs, the dissent rejected the argument that another law, Section 122 of the Trade Act of 1974, which deals with general balance of payments issues, should have taken precedence over IEPA. They highlighted that the reciprocal tariffs were specifically designed to address goods trade deficits causing manufacturing deficiencies. That, they argued, was a different underlying problem than the general balance of payments issues Section 122 covers. So, in their view, IEPA was still the appropriate tool. Two very different readings of the same laws.
Fascinating how the same words can be interpreted so differently. Okay, so the Federal Circuit struck down these tariffs. Big news. But the story isn't quite over because the court also vacated the universal injunction that the lower court had issued. What does vacated mean here, and what's the practical effect?
To vacate means they essentially hit the undo button on that specific part of the lower court's ruling, the part about the injunction applying universally.
So the injunction itself is gone?
Not necessarily the idea of an injunction, but the scope of it. The case is now remanded, which means sent back down to the lower court, the Court of International Trade. And that court will now have to reconsider the specific scope of its injunction, who it applies to, how broad it is guided by recent Supreme Court precedent on how widely these kinds of court orders can apply.
So bottom line, the tariffs themselves were found unlawful by the appeals court.
Correct.
But the specific method of stopping them universally for all affected parties is now going back for another look.
Exactly. It's an important procedural distinction. The substance, the illegality of the tariff under IEPA stands, but the remedy needs refinement.
So wrapping your head around all this, what does it ultimately mean for you, the listener? This ruling, it feels like a big win for those who believe in strict limits on presidential power, especially when it comes to taxing and trading.
It certainly is. It clearly signals that Congress holds the power of the purse, that Article I power.
But crucially, it doesn't necessarily mean the end of tariffs altogether, does it?
No, that's a really crucial point to understand. This ruling specifically addresses the use of IEPA for these tariffs. So this raises the important question. If not IEPA, what other cards does the executive branch have left to play if it wants to impose tariffs?
Are there other tools in the toolbox?
Our sources point to a key alternative, Section 301 of the Trade Act of 1974.
Section 301, we've heard that one before.
Indeed. This law grants the president, acting through the U.S. Trade Representative, the USTR, pretty broad authority to impose tariffs on countries engaging in what the USTR determines are unfair trade practices.
So the president could potentially just use a different legal pathway to achieve a similar result. What are the implications there?
Well, Section 301 does require more process investigations, reports, public comment than just declaring a broad IEPA emergency.
More paperwork.
Definitely more paperwork. But the definition of unfair is often quite vague, giving the USTR a lot of discretion. And here's the real kicker. Courts typically review only the procedural steps of the USTR's actions under Section 301, not usually the underlying merits of whether a foreign practice is truly unfair.
So less judicial scrutiny on the substance.
Often, yes.
No.
What's more, there's no explicit legal limit on how high tariffs can go under Section 301.
Wow. No ceiling.
No explicit ceiling in the statute. However, it's not necessarily a completely free pass either. There are existing lawsuits challenging prior Section 301 tariffs. And potentially, the major questions doctrine, the same one used in the IEPA case, could be argued to apply here too.
So that doctrine might come back.
It's possible. Some argue it could limit agency power, like the USTR's, even more strictly than direct presidential power. So, while Section 301 is definitely an alternative pathway, it's not without its own potential legal hurdles.
Okay, so the legal battles might just shift arenas. Regardless of the specific law used, the impact on businesses and consumers, well, that's already been felt, hasn't it?
Oh, absolutely. Even if these IEPA tariffs were ultimately struck down, their existence, even temporarily, led to higher prices for many goods, significant delays in shipments, real difficulty sourcing parts for manufacturers.
And squeezed profit margins.
Definitely. Especially for companies relying heavily on imports from countries like China, Canada, and Mexico.
Yeah.
And just the continued uncertainty itself, not knowing what the rules will be next month or next year, that's a huge challenge for long-term business planning and investment.
It really underscores how these high-level legal decisions ripple outwards. This whole exploration, it's shown us this intricate dance between executive power, congressional authority, and judicial review, all playing out in the incredibly high-stakes arena of international trade.
Yeah, and the court's decision here, it really clearly reaffirms that Congress holds that power of the purse. Any delegation of that taxing or tariffing power, the court is saying, must be explicit and clearly defined. It can't just be assumed under broad emergency statutes like IEPA.
The message seems to be, if you want to levy taxes, ask Congress directly.
That's the constitutional structure the court upheld. The message to the executive branch is pretty clear. When it comes to taxes and broad economic policy changes like these tariffs, you need specific, unequivocal permission from the legislature.
So for you, the listener, the takeaway here seems clear. Understanding these legal nuances, even if they seem complex, is really vital because they directly influence the global economy and ultimately what you pay for everyday goods.
Absolutely. It's not just abstract law. It's the hidden machinery affecting your wallet and the choices available to you in the marketplace.
So let's leave you with a final provocative thought to mull over.
Considering everything we've discussed, does the executive branch, perhaps in times of perceived national emergency, need more flexibility to impose broad economic measures like tariffs, even if it means blurring those traditional lines of constitutional powers?
Or is the preservation of that strict separation of powers, even if it seems slower or sometimes less efficient, ultimately more crucial for long-term economic stability and, perhaps more importantly, for democratic accountability?
Something to think about.
That's it for this deep dive. We hope you feel much better informed and maybe just a little more curious about the hidden forces shaping our world.